In this item number 9.
You have to release it.
এটা কি এটা খোঁজ নিন দেখুন তারপর আমরা অর্ডার করব ঠিক আছে সরিয়ে রাখুন হ্যাঁ to be mentioned tomorrow.
To be mentioned tomorrow.
Release this later, huh? Under heading to
Sleep though. My lord, can it be fixed day after tomorrow? To be mentioned.
You want day after tomorrow?
Day after tomorrow.
All right, day after tomorrow.
Grateful. Grateful.
Ten is defective. State's appeal. Where is this?
Actually, the impanel advocates were there in the erstwhile panel. They haven't returned the brief yet.
All right.
So either I have to collect it from the respondent, but the respondents are also not here. On my request, not let it be placed before the next circuit bench or on Monday, whatever my lords is convenient for my lords. Because we do not have a copy of the brief.
Order was passed by which bench? Second August 2023. And it key justice. On the prayer of the learned Triple AG. List the matter in the next circuit.
I'm before this. Next circuit, I have brief.
My lord, item number 11, I'm led by Ekramul Bari in this matter. My lord, may kindly be pleased to fix it on 9th. He's going to come physically because this needs his presence.
Who's for the state?
Your Lordship, I am appearing for estate.
And are you ready with the matter? Are you aware?
Yes, Your Lordship, if you. Your Lordship, this is for the service observation, Your Lordship. But there is, when I am going through the plan, I can see easily there is a break in service, no continuation in break.
That is on merits.
Yes, Your
All right.
Lordship.
You want it on 9th?
9th, my lord. He's going to appear physically. So why he's going to appear physically?
You want it on the 9th. Why not before that? Let him join virtually, no difficulty.
My lord, then I have to take instruction because he specifically requested me to request lordships to fix it on 9th because.
No, just prior to the completion of this circuit, it will be difficult.
Because there is, I think, my lord, there are one appeal regarding the GTA matters, a bunch of GTA matters which has been appealed before your lordships. So Mr. Bari has to appear on 9th and it is fixed on 9th, I presume, as per his instruction. So
let's see. All right. On the prayer made on behalf of the learned advocate representing the appellant, list the matter on 9th July.
grateful.
Grateful, Your Lordship.
9 तारीख है।
My lord, may I appear my lord, virtually, my lord, in this matter? My lord, application for condemnation of delay is there, my lord. There is, my lord, 51 days delay. In my application, my lord, from paragraph 4 onwards, my lord, I have explained why the delay has been caused. My lord is not visible, my lord.
Who's appearing for the Union of India?
My lord, I presume that my lord service has been affected. My lord, the advocate record may be there, my lord. The service has been affected long ago, my lord. Because in the last circuit bench also this matter appeared. My lord is not visible, my lord. I am not in a position to, my lord.
And for the state,
I am happy, Your Lordship.
do you have copy of the brief?
No, Your Lordship, kindly, if it is not allowed, copy. Your Lordship, so.
Sorry, madam, she is not in that one. Well, we have
For the
state,
state?
yes, state has brief.
My lord, some technical
51
issues.
days.
My lord, 51 days, my
51
lord.
days delay, we condone it?
Sorry.
51 days delay.
Yes, yes, madam.
That
I'll
can
leave
be
it- I'll leave
condoned.
it to your lordship.
What do you have on merits to say?
My lord, on merits, my lord, I am ready to, my lord, argue, but my lord, some technical problems are there, my lord. My lord is not visible, my lord. I can, my lord, see your lordship, my lord, the court.
Can you hear? Can you
My lord, I
hear
can-
the court?
My lord, my lord, my lord.
Then we can see you. Do not worry. You can proceed with the hearing.
My lord, may I submit, my lord? My lord, kindly have a look to the impugned order, my lord, at page 146, 147 of my application number 2.
Yes.
My lord, the two parts are there, my lord, in the order, my lord. One part is, my lord, the railway authorities, my lord, suppress the material facts that they do not have any documents with regard to the, my lord, land acquisition. And, my lord, the second part is, my lord, kindly have a look, my lord, the order, my lord, that is, my lord, at page 147.
See,
My lord,
first of all, we see that the writ petition, 1 minute, the writ petition was by the Union of India.
my lord,
You possibly were the private party over there.
my lord, my lord, my lord.
And there the court has merely mentioned that the matter will be before the Land Reforms Tribunal. Where
My
is
lord,
the
that
error?
is, my lord, that is the time part because the, my lord, order was passed in the year 2017. My lord, by this writ petition, my lord, very cleverly the, my lord, the liberty has been, my lord, opposed, and my lord, that is, my lord, totally time barred because, my lord, the impugned order was passed in 2017 and railway authorities, my lord, railway authorities appeared, contested that proceeding, submitted the documents, and, my lord, the impugned order in that proceeding was passed in their presence. My lord, but, my lord, they did not, my lord, prefer any appeal at the relevant point of time. Now, my lord, what is my case? My lord, my case, my lord, my predecessors had the, my lord, several plots of land. Out of that, my lord, a portion has been, my lord, acquired by the, my lord, railway authorities. My lord, in the year 1960. My lord, I have no my lord, claim or demand over the, they said, acquisition proceeding. But, my lord, the railway authorities have forcefully, my lord, captured and in possession of the other properties which have not been acquired and not in consonance manner with the Gazette notification which was published in the year 1960. And my lord, the railway authority.
Did you approach? Did you approach any
Yes, my lord, I
judicial
filed writ
forum?
petition. My lord, I filed writ petition on earlier occasion. My lord, that is my lord.
Where is
it
your writ?
My lord,
Where is your writ? We can see only 18th of February's order in a writ petition filed by the Union of India.
no, my
Where
lord,
is
my
your
writ
writ
petition.
petition?
My lord, kindly have a look, my lord, page 89, my lord. My lord, kindly have a look, my lord, page 89. My lord, that is the, my lord, my writ petition wrongly, my lord, it was corrected, my lord, wrongly recorded as 2462 of 2021, my lord, it should be, my lord, 2462 of 2025. My lord, later, subsequently, the number was, my lord, corrected by his lordship. My lord, this is my writ petition. My lord, in this writ petition, my lord, the respondents authorities, my lord, had been directed to, my lord, consider my representation. Well, in spite of that, when the pending adjudication of that consideration by the respondent authorities, DM, district magistrate, railway authorities filed this writ petition motivatedly, only with the sole purpose of getting liberty from this honorable court to approach the learned LRTT for appeal, which was passed in the year 2017. Now,
If,
kindly
see,
have a look,
as on date, did you all approach
Madam.
LRTT?
Lots, already
You all have
filed.
approached.
Already filed your lots.
You have approached. Why don't
Already
you go and raise all objection before the LRTT? What will the appeal court do over here?
My lord, kindly
The matter is
appreciate, my lord.
LRTT.
My lord, kindly appreciate, my lord. My predicament, my lord, is, my lord, kindly have a look to page 68. My lord, the railway authorities suppressed the entire material facts before this honorable court that they don't have any
How the
documents.
Read Court can consider whether
No, my lord,
suppression
my lord,
or
the
other
documents are
facts
there.
can
It is
be
their
cited in
document.
your
My lord, kindly have a look to
website.
page. My lord, kindly have a look to page 69. Lordship kindly once, my lord, looks for my satisfaction. My lord, kindly have a look, my lord, page 69, my lord. But this is the, my lord, proceeding of 2017. The order was passed in 2017. Now in the year
You raise
2020,
all points before LRTT.
my lord, kindly have a mark for my satisfaction. Lordship, kindly have a look, page 69. My lord, kindly have a look, my lord, page 69, my lord. Kindly have a look, my lord.
Where have you mentioned that the matter is pending before LRTT? What is the case number?
No, why you are asking for documents in your writ petition?
My lord, this land was handed over to the repository by the state department. Now, there was a dispute as to the acquisition proceeding and acquisition mode. While we were trying to approach the district magistrate and apprise the district magistrate about the proper situation that was prevailing, we needed documents as to, like, my lord, what are the.
To ascertain the
My lord,
actual position or
that was
status
not
of
with
the
us.
proceeding.
Yes, that was not. with
That
us.
was your prayer.
After failing to obtain them by the normal process, when we could not get any document out of the state,
You
we
filed
had
it.
to approach the Read Court, asking for a direction that the state may be directed to give us the relevant documents of acquisition.
My lord, page 69.
We are not challenging-
Wait,
Yes,
sir,
My lord,
wait.
we are not challenging anything. We are just trying to ascertain where we stand.
So you approach the
Yeah, we have
WPLRT
already
only for supply of documents?
No, we have, after that, we have challenged the entire gamut to the LRT.
Proceeding will be.
Because LRT is the appropriate forum where we can agitate our demand.
My lord, kindly have a look, my lord, page
My
69.
learned friend
My lord,
has any
everything will be
remarks,
clear. My lord,
counter
kindly have a look, my lord.
remarks, he is welcome to
Page
the
69, my lord, it is, my lord, not the actual state of affairs. My lord, kindly have a look, page 69. My lord, here it is clearly written, the North Frontier Railway Authorities today submitted a copy of declaration made by the LA collector under section 6 of the LA Act 1894, revealing the details of land needed for acquisition bearing number such and such. Well, they appeared, they contested, they submitted all documents. Now, with my unclean
all
hands,
these
they
facts-
approach this honorable court.
If
Well,
the
this-
LRTT has been approached by the union, you are a party over there, you raise all points over there.
Well, I don't know whether, my lord, I have not been served with the copy, but my lord, my humble submission before lordship, my lord, the railway authorities, my lord, have suppressed the entire material facts before this honorable court and obtained the order by way of, my lord, suppression of material facts. My lord, record speaks
You
of.
were present. When the order was passed by the trial court, you were present,
Yes, Javed is.
right?
My lord,
Then
Javed is represented.
you were represented.
Yes, Lord.
my lord, at that
This
time, my
407
lord,
was-
my lord, at that time, my lord, all documents were not, my lord, available with the,
Then
my
that
lord,
is your problem.
The learned advocate was
I was
representing him.
not
He
there,
cannot.
my lord. Well, I was not
Cannot
there in
force
that
such
proceeding, my lord.
Now
And
you-
my,
That it hardly matters.
No, no, he was hurt, my lord.
my lord,
Every
my
appeal
humble
was defended.
submission before your lordship. Lordship kindly appreciate. Can, my lord, I put this question: can a time but claim, my lord, appeal can be, my lord, entertained by virtue of the liberty, my lord, granted by this honorable
The
All
court has
points-
not entertained anything.
All point may be raised before the WSRT.
Please tell me the number, OA number.
Lord, Lord, will collect.
We'll collect.
Right, I will give me 5 minutes. madam. We just-
All right. We'll insert it in the order sheet so that the appellant also gets to know.
Madam,
Are
we'll
you
supply.
aware?
No, my lord,
No.
I'm the state.
Maybe the state. It
Not
is
aware.
you are the acquiring body.
They have approached the LRTT. We
Madam,
You are a party also.
madam, may pass the order, I'll supply that.
are passing the buck.
Section 5.
Always you do, sir.
Appeal has been
Now
preferred
it is
by
more
the
easier.
private respondent in the writ petition. After a delay of 51 days, stop, comma, being satisfied with the explanation mentioned in the application seeking condonation of delay, comma, we allow the section 5 application and take up the main appeal for hearing. Stop. We have heard the submissions made on behalf of all the parties, paragraph the legal. Stop. It appears that the appellant was included as respondent number 7 in the writ petition. Stop. The writ petition was filed by the Union of India. Stop. The learned single judge merely recorded that it will be open for the petitioners, not open, that the petitioners shall be at liberty to approach the West Bengal Land Reforms and Tenancy Tribunal in connection with the relief prayed for under prayer B of the writ petition. Stop. The writ petition was entertained only with regard to relief prayed for under prayer A, directing the state respondents to supply documents to the writ petitioner as prayed for within a stipulated time period. Paragraph. The appellant herein was heard at the heard by the learned single judge. Stop. It has been brought to the knowledge of the court that the Union of India has already approached the West Bengal Land Reforms and Tenancy Tribunal by filing application being number such and such. Paragraph. Specific point taken by the appellant is that the claim of the writ petitioner, that is the Union of India, is a time-barred claim and the writ court ought not to have entertained the same. Stop. Upon hearing the appellant and upon perusal of the records, it appears that the learned single judge was pleased not to adjudicate the grievance on merits, not grievance, dispute on merits. Stop. The learned trial judge merely granted liberty to the petitioner to approach the West Bengal Land Reforms and Tenancy Tribunal. Stop. Paragraph. As the writ petitioner has already approached the tribunal in the meantime, comma, comma, not comma, impleading the appellant as a party in the said application, comma, it will be open for the appellant herein to raise all points before the tribunal.
Including the point of limitation, my lord. My lord, including the point
All
of
points.
limitation, my lord.
All points. We are not specifically mentioning all points. You may have other
If
points
you-
also on merits.
My lord,
Why
if
keep
including-
it restricted to limitation?
Only, including
All
limitation.
points.
My lord, my lord. My lord.
Stop. As no other point has been raised in the appeal, comma, the appeal along with the connected application for stay stands disposed of.
Madam, please apply the order, A order.
Yes. You have you collected?
We just go outside the court and collect.
Deeply obliged. my lord.
Your Lordship, I'm for that.
But I am for the stay. But we have been served with a copy of the stay application. A copy of the memorandum of appeal, it may be served up. That is not been served. Possibly, my lord, this is beyond time.
101 days delay.
Your Lordship, I'm praying for fixing this matter on next Tuesday. Lord. Mr.
Why?
Shah is in this matter. He wants to do
Where
it
is the section
physically.
5 application? It cannot be taken up for consideration without the application. We fix it. In the meantime, you file the section 5 and serve a copy of the memo.
All right.
All right. Accommodation
After
has been
filing
sought
appeal,
for
why do not check the official report,
on
staff
behalf
report?
of the appellant.
You must have to check.
Yeah, my lord, one difficulty we are
Yeah,
facing,
please.
what has fallen from your lordship is correct. We should be,
With every
we should be more
defect, we
vigilant,
have
my
to
lord,
pass
because
order.
I was there about 10 days ago also. But since the Lojima bench is not there, the defect, the problem comes here, my lord.
No, you
See,
can
these are
inquire.
writ petitions.
Yes.
You know the date of the order and the date of the filing. You do not require SR report to know how many days
Yes,
delay. You
sir.
can calculate.
Yes,
and
we
file
can.
an
This
appeal.
is
We can.
something, what does the Lojima got to do with this?
No, we then see, my lord, how many days.
Lojima,
and
you do not comply the or cure the
Lojima
defect.
No, that, my lord, I am not trying
Then
to
only
defend.
Lojima
Other
court.
civil matters and everything, Lojima is already. Writ petitions, all dates are there. You know how many days delay. Achha. It appears from the SR report that the appeal has been filed out of time. Stop. No application seeking condonation of delay is on record. Stop. On the prayer made on behalf of the appellant, the matter stands adjourned till when you want it?
Tuesday. Lord.
Tuesday. All right, 7th July.
Great.
The defect may be cured in the meantime. পুরো ক্লার্কের কাজ judicial as
Lordship, for item number 14, I'm praying for next,
Praying
Yes,
for
next circuit.
why?
why?
Lordship, the conducting counsel has instructed me that he needs to take further instructions from the client.
The writ petition also was dismissed because there is a equal efficacious remedy in the form that the GST tribunal is not functional. And they have to avail that remedy. in
Yesterday,
accordance-
this matter was taken up, isn't
Yes,
it?
Yes,
Your
ma'am.
Lordship, Mr. Lakhotia is the conducting
Right,
counsel.
then
He's on his legs in court number
let him
5,
come.
but
No.
Let him come. We'll remand it to the tribunal. No adjournment.
Lordship, we have to ask the
Pass over,
client
you ask
as
him
well,
to come.
the
What
petition.
will the client say? The
Lordship-
court will dismiss, the client will take steps. Nothing doing. And then you will come seeking time to condone the delay in preferring the appeal and all these things will arise. So no, we'll finish it off here. I don't know, please. Item 15. Yes.
Lordship, I'm appearing on behalf of the appellant. Am I audible, Lordship?
Yes, I can hear. The court can hear you.
Lordship, in this appeal, some defects were there, but I have complied all those defects to Lordship, but still it is some defects are showing in the from the court list I come to know. So Lordship, I'll clear all the defects. Lordship, even court is not visible.
We cannot
We are
follow you.
unable to hear you, what you are saying.
Lordship, am I audible in Lordship?
Yes, audible, but not so much clear.
Lordship, in this matter, in this appeal, some defects are there. I'm praying for kindly keep the matter in the next circuit. Meanwhile, I'll clear all the defects, Your Lordship.
The matter relates to GST. The tribunal is functioning. Why will the matter not be remanded to the tribunal? Your
Lordship,
writ
we have
petition has
challenged the
already been
single-
disposed of.
There is
We
no
have challenged
Alternative
the-
remedy is there.
That copy.
We have challenged the single bench's order, Your Lordship.
Why you have not filed the certified copy till date?
Lordship, I have applied for the certified copy, and with the liberty of the court, I have filed the map.
But you have to file the certified copy, that is only the defects.
Lordship, I'll clear the defects. Kindly place the matter in the next circuit.
We are remanding the matter to the tribunal. We are not interfering. This is the reason.
Lordship, then in this case, Lanet, my senior Mr. Bodhan Bhattacharya is to appear in this matter, Your Lordship. Then I'm paying for a not today.
We make it clear that we will remand it to the tribunal. That is the order of the learned single judge. So you have to go there and we will not interfere. Where is your senior?
Tribunal has already constituted and
Yes.
we have to
Lordship,
file.
please
Lords,
document your Lordship.
if I may say, Lord, the High Court of Madras, the High Court of Allahabad, the High Court of Odisha, I have all the judgments, Lord. The High Court of Guwahati, all of them are remanding the matter back to the tribunal now. Because the tribunal is up and about, it is operational and functional.
We are sending it to the tribunal, right?
Lordship, then I'm paying for 2 days accommodation, Your Lordship. My learned senior
no.
is coming before, appear before Your Lordship physically.
Maximum not today.
Kindly put the matter in the Thursday, this Thursday, Lordship.
All right, Thursday on the prayer.
On the
Thursday. We will also dismiss it on the same ground. Yes. On the 11.
Wait for you, Lordship.
Lordship, I am appearing for the Union of India, Lordship.
Yes. You were supposed to file a rejoinder.
Yes, Milord.
Lordship, I am not filing any rejoinder because I will relied, because this is purely a case of sections, interpretation of sections. Because this case is pertains to
You want to
audit.
file or you do not want to file?
Yes, no.
No, you
We
don't.
will assist on the
Basis of whatever is there on record.
record or as per the law.
Yes, yes.
So then Milord kindly takes it up tomorrow, Milord. I was under the impression that they will file a rejoinder if I have to make an exception to that. So kindly takes it up tomorrow, Milord.
Lordship,
I will
they
ask.
have taken
This is
4
also
circuits,
regard-
Lordship.
1 minute. Is this regarding the GST?
Yes,
No,
Milord.
Lordship, this is purely an audit matter.
Let it go before the tribunal.
No, Milord, it's not a matter to be remitted to the tribunal
Why?
because we have challenged, Milord, audit notice.
Yes.
It's
And the
directly.
tribunal cannot decide it.
Tribunal, Milord, tribunal only comes in, Milord, when there is an appellate order in place under 107. So here, Milord, there is no original adjudication order, no appellate order. We have straight away challenged the notice before the High Court. Single bench has taken a decision. We have come up against that decision of the Honorable Single Judge.
So what is there to adjudicate at this stage?
Yes,
Milord,
Lordship.
Milord,
It is not adjudicated,
Milord,
only
I'll-
the intimation we have
Milord, I'll
We have
show-
only issued the intimation they have challenged the intimations, which is not
Well, the
permissible because,
intimation has to be in accordance with law and according to the extant circular.
so that's why.
Our submission is it is contrary to the law and the circular. We have filed a supplementary affidavit also annexing the circular. So kindly takes it up tomorrow, I'll argue.
So in
They
this
cannot
case,
undertake the audit.
No, they can.
yes, that's why.
But the
I have
time
got the
limit-
only the small request, that is because they have prolonged the audit for 1 year for this ground and that ground. No,
Where is
only
the
just,
copy
I
of
am
the
just,
petition?
yes,
It has been filed by.
I only want,
So
if
it
they
is in our
want,
Supplementary affidavit.
if
Is the
they,
writ petition annexed?
Yes, in the supplementary.
if they want to, all the,
Not
because,
today, we'll make
Not
it.
today, tomorrow we will hear.
because this is a very limited issue, my prayer is that let me allow to do the audit and they cooperate. Only this simple prayer, Lordship. Nothing. They have done a lot. They are saying it is the barred by limitation or
All right,
whatever,
they
because
say
the
that-
section doesn't say so. So I only lay down the sections, so that will clear the things. And they last from
He is
the
not prepared,
6
so
months, they are dragging this case.
Tomorrow.
This is-
No difficulty.
You prepare
Take down
yourself.
an order. Learned advocate representing the respondent submits that the authority will not file a rejoinder. Stop, the authority intends to argue the matter relying on the basis of the documents already available on record. Stop.
And on the law point, Lordship.
Law
Yes,
is
yes,
always there.
Lordship,
That is
Lordship.
nothing. You cannot argue something which is illegal, isn't
Definitely.
it? It's always in accordance with.
So Lordship, we are facing 1 year, they are not able to carry out this is a procedural matter. So
Sir,
only
no one has
prayer,
stopped you
only
doing in
prayer.
accordance with law. That
So
is-
only that,
List
because
tomorrow.
we have given a notice, there is a no order of single judge restraining the audit. The advocate sent us a notice reply that matter is sub judice before the division bench, so you cannot do the audit. So this is the position. So that's why my humble prayer is only, he is also with me agreed that we can conduct the audit and they can cooperate in audit. That's the simple the solution, Lordship. Because audit is only a statutory proceedings. It is not a adjudication.
All right, tomorrow.
Lordship. Lordship, can it be
Yes.
Under the same heading, it will appear, no problem.
Why you want adjournment?
No.
Then
It can be preponed some like
No,
that.
especially fixed.
Report
period is
means-
done.
today it is there, tomorrow it will remain.
Yes.
Where to
Lordship,
report?
Lordship. No.
My lord, I am appealing for the appellant.
Item number 18, my lords, I'm for the respondent, because conducting counsel is not present today due to some difficulties. The conducting counsel is not present today due to some personal difficulties. I'm praying for not.
My lord,
Yes.
they were supposed to file a affidavit in opposition in this matter, and they have already served a copy upon us. And we are intending to file an affidavit in reply against that affidavit in opposition. Kindly fix the matter on Monday so that we can file the reply and the matter can be taken up for final hearing. This appeal is against an
Was there a possibility of an amicable settlement?
amicable settlement was initially done by the honorable court.
Then?
And they failed to perform their part of obligation under that settlement, and subsequently that order was recalled by this honorable court on the last circuit. The matter is placed for hearing on merit.
You can see your order.
This was a suit for specific performance of contract.
Issues in the appeal suit are to be settled amicably. You are there. 2024. Suppose that the contract attached for you.
Last order, my lord, the settlement order was recalled.
The order was recalled.
Yes. Because this was a suit for specific performance of contract. They paid a very meager amount, and subsequently they said they are ready and willing. The honorable
No, the
court,
degree has been drawn up. Thereafter,
this
thereafter
honorable court,
recalled.
this honorable, No decree was drawn up. It was supposed to be drawn up by the trial court.
Yes.
Since they failed to perform their obligation under that settlement, within 20 working days, they will pay the entire amount, but they did not pay. So decree has not been drawn up.
The execution, you have to file the execution.
Now, this
case.
is shoot for a specific performance of contract. If they do not pay the amount,
If the matter has been settled out of court, and settlement, term of settlement
Honorable
was
Court has
taken as
already
a
recalled.
degree.
You want recalling now?
No, it has already been recalled.
By which order?
Which
By
order?
the last order, my lord, that is on.
কি বলে
That is
এটা?
order dated 8/6/2026.
8/6.
Where is the order of 8/6?
এতে আছে। আপনার ওটা খালি আছে না?
8/6.
Coordinate bills. The background of the case is pretty clear. And 15 disposed of in terms of the decree of settlement, terms of settlement, and particularly decree be passed. However, in the present application submits its several common on this certain particulars, it's also restricts time to recall, seeks the recall of the order. So regards the contention of the services in the previous transactions, and if we need, we can have to comply. So, when we find that the parties are not adapting, we can be appeal being required to be heard and merits upon recall. The recall will be appealed before on 30 lakhs for a different time. 50 lakhs of evidence recorded in the court by a different time. It is recall the order recorded. This will be a contested hearing. Letting file application will be in the next side. What do you want to file now?
My lord, not the hearing of this appeal on merit. That is a
No, you said you want to file some application.
affidavit in reply. They have already filed the affidavit in opposition. They did not file it to the court, but they served a copy upon us.
Yes.
And we want to use affidavit in
Where is
reply.
the copy of opposition?
Original has to come before the court.
Yes, my lords. Conducting counsel is not present today, my lords. Let it be tomorrow. You will come with all the documents.
Would you like to file it when?
Yes,
How
Lord.
much time you require?
2 days maximum.
2 days.
Next week. Please come. Learned advocate representing the appellant submits that copy of the affidavit in opposition in connection with the application has been served. Stop. The appellant intends to file a reply to the same. Stop. Accommodation has been sought for on behalf of the learned advocate representing the respondent. Stop. In view of such submission, release the matter on 8th July 2026. Stop. Reply may be filed on the adjourned date. Now, the affidavit in opposition and the reply may be filed before the court on the adjourned date.
And copy of the same be served in advance. Copy of the reply is.
Please serve the copy.
Yes. Great to know.
It has drawn up hard in me. ওই স্টেজে থেকে রিটার্ন করে দিতে আছে 19. It has not been complete. 19. 19 Dismiss for default interim order vacated. This is for restoration. Dismissed.
Can,
It is for restoration. Nobody is there.
can one,
Dismissed.
can one is dismissed, can one.
Dismissed for default. Dismissed. I'll give.
Already dismissed.
Item number 20.
My lordship, service has been affected, but I could not prepare the affidavit of service.
Service has been affected.
Yes,
Did the respondent receive?
yes, my lordship.
Can three. This is can three need. This
Can
is
3 has been
one,
disposed. This is can 1.
can one.
Can one is section 5, can 2 is state. There is a delay of 2,374 days.
And what is can three and can four?
It was a restoration petition.
Dismiss for default. That has been allowed.
It was allowed.
What is the matter about?
Misprobate. Probate case.
Probate case.
Because it can.
Substitution
is
is
can one?
required.
Can one bar.
First title given. So many defects. Did you check up the SR report?
No.
Check up. There are so many defects.
It's a restoration for restoration option. Can one, what is the can one? Item number it about 20.
1570 days.
Item number 20.
The cost title of the the child could die and explain the report will not and record application to each There was a direction for curing the defects. Did you cure it? Defects has not been cured by the appellant. Why don't you cure the defects?
I will cure it.
Can 2025. ডিসমিস হয়েছে রেস্টোর হয়েছে কেন এখন মানে আপিলটা অ্যাডমিট
অ্যাডমিনটা তো অ্যাপিলে there are so many defects. এই ডিফেক্ট গুলো না কিওর করলে কি করে অ্যাডমিট হবে?
তারপর ওটা যখন কি হচ্ছে প্ল্যান টু সেফটি
Can do it a stay. There is a delay of 1750 days. Learned advocate appearing for the appellant. Appellant submits that service has been effected upon the respondents. Stop. The affidavit of service, however, is not prepared. Stop. The appellant is directed to prepare the affidavit of service and file the same on the adjourned date. Stop. The appellant is also directed to cure the defects as pointed out by the stamp reporter. List the matter before the next circuit.
Sir.
Please check, there are a lot of defects and there was direction for curing it earlier. If you do not cure, then next time your appeal will go.
None.
Dismissed. Is your order. Dismissing. Dismissed. Can. The appeal was dismissed earlier, so nothing remains.
Item number 22.
For the applicant, my lord, I'm for respondent number 1 to 3. My lord, my clients had received the application for restoration last night, so they could not give it us today. My lord, may kindly give it on Thursday, my lord. The appeal may be restored. It's a dismissal for default. It was.
Is there any delay in filing
there is no
the
delay. Within time it is filed.
application for restoration? There is no delay.
There is no delay. It was dismissed for default on 21st of April, and on 20th of May it was filed.
On appeal, the 21st of April, it stood dismissed. 20th of May. Copy fine.
Copy already.
We have not seen the copy.
It has been filed within time, so we restore it.
And my lords, I stand on instructions, my lord.
What
I make-
instruction you need for restoration?
Material instruction. Tomorrow?
Tomorrow, my lord.
Tomorrow.
Tomorrow, then can you day after tomorrow?
The day after tomorrow.
Grateful.
Item number 23.
Mala, I am for the applicant, Mala. This is a matter regarding Mala, appeal against the matrimonial court, Mala. On the last of. Yes, Mala. Their lordship directed to serve the other side, Mala. I am not videoable, Mala. Video connection is out, Mala. That is, I am continuing my argument, Mala. Your lordship, kindly take it up Friday, Mala, third, because I have already served the other side, Mala. So you lordship, kindly take it up third, Mala, Friday, Mala. That I can produce, Mala, available service, Mala. Maja disturb. Well, I am not videoable, my lord. Video connection is gone, my lord.
This is the restoration page.
It has already restored.
Where is your affidavit of service?
My lord, that is why, my lord, service not effective, my lord. That is on the way, my lord. But you will kindly take it at third of, my lord, Friday, my lord. I will come, my lord, circuit bench, my lord. In the meantime, I will prepare, my lord, review service also, my lord. Kindly take it up third of July, my lord, Friday.
On the prayer of the learned advocate representing the appellant, list on third. Always in the meantime.
Yes, my lord. Prepare.
Time for the appellant, my lord. My lord, the copy of the application has been sent, delivered, but yet not. It has been sent to the respondents, but have not been delivered as of now, my lord. My lords, may kindly keeps it in the next week, Monday or Tuesday, my lords.
What is the application for?
My lord, it is for, my lord, it's a delay application. The application was sent last week, my lord, so not get delivered.
There are other defects pointed out by the SR. Did you check up?
No, my lords, I'm not really aware of the defects, my lord.
2,376 days delay. And apart from that, there are other defects. Without curing the defects, the matter cannot be heard. There was a direction for curing the defects by the last, in the last circuit.
Why
What
do
have
you
you done?
not follow the direction of this court? Are you
Lord, will-
interested in proceeding?
My lord will look into it, my lord, and will cure the defects.
Despite direction, you did not cure the defect.
Please take down. It appears from the report of the stamped reporter that there are several defects. Stop. The appellants are directed to take steps for curing the same. Service has not been effected till date. Stop. List in the next circuit.
I don't know, 25. Lordship, I am appearing for the appellant. Lordship, this instant appeal judgment and order dated 15 September 2025 and decree dated 19 September 2025 passed by learned additional district judge fast track court at Kuch Bihar in matrimonial suit number 156 of 2024 for a decree of divorce which was dismissed. A delay of some
Yes,
time has
but-
been. Lordship,
Onion.
All right. একটু দেখুন তো এটা কি প্রবলেম হচ্ছে, এফিডেভিট অ্যাফর্ম করতে পারছে না জেল থেকে। ওকালতনামা is there or not? Signed in jail? All right. দেখুন তো কি করা যায়। হ্যাঁ, কমিশনার ওখান থেকে একটু দেখে নিন না কি করতে হবে। All right. An order has been passed. All orders have been passed yesterday. What is the order? Order will be put up in the server. Please check up and then mention. No. It cannot be done. See what is the order passed. Even I don't know what order has been passed. Then you mention. Yes, please.
Item number one, my lord, I appear for the petitioner. This is, my lord, my application seeking extension of time, my lord, for the arbitral tribunal to make and prepare the award, my lord, under section 29A. My lord, the panel was 3 arbitrators. My lord, the delay is because, my lord, the presiding arbitrator, after the evidence was completed, my lord, Mr. Lokhi Gupta, he had fallen ill. My lord, he had cancer and he had to, my lord, be shifted to hospital in Bombay. Thereafter, my lord, the matter was kept for final arguments, but in the meantime, my lord, the original, my lord, mandate had expired. The respondent, my lord, is a government entity. My lord, they had sought time to file consent, my lord, give their consent. Ultimately, they did not give their consent, which is why, my lord, I'm before the my lord, court today. Paragraph 2, my lord, of my petition, I've set out, my lord, the, my lord, constitution of the tribunal, my lord, at page 3 of my petition. My lord, thereafter, my lord, page 14, my lord, the first sitting of the tribunal was held on 20th January, my lord, where, my lord, the directions were given for filing of pleadings. The pleadings, my lord, were completed on 21st November 2024. My lord will find this at page 29.
Please show me the order of the court. Show me the order of the court, 22nd of August.
My lord, the order, my lord, is not annexed, my lord, to the petition. May I, my lord, request my colleague, my lord, who is present in court to, my lord, hand up the orders. It's actually, my lord, a total of, my lord, 3 orders. Because, my lord, the initial appointees, my lord, had, my lord, not, my lord, formed the tribunal. May I, my lord, request my colleague who is present in court to, my lord, hand over those 3 orders. The 22nd
Was
August
any
20
timeline specified? Was any timeline specified by the court within which the award had to be passed?
No, my lord. My lord, the timelines are, my lord, specified under the statute, my lord, under the Arbitration Act.
Yes. Apart from that, nothing was mentioned.
Apart from that, my lord, nothing was mentioned. My
All
lord,
right, now the time has expired.
yes, my lord. My lord, which
And
is
when
why,
did the time expire?
my lord,
When did the time expire?
The time would have expired, my lord, on 21st November 2025. I have, my lord, prepared a short list, 2-page list of dates. May I, my lord, hand
Yes.
over list of dates? It will become easier, my lord, for the court. My lord, my lord, on the first page at the bottom, my lord will find reference to the 19th sitting of the tribunal on 21st November 2024. This is, my lord, at page 29 of my petition. This is when, my lord, the respondent filed its amended counterclaim, which was allowed. So this, my lord, would be the date for completion of pleadings. Under section 29A, subsection 1, the award, my lord, is to be passed within 1 year from this date. So this date, my lord, would have expired. My lord will find on the next page of the list of dates, my lord, 21st November 2025. The entry, my lord, just before that entry, my lord, 26th July 2025, my lord will see that the witness, my lord, examination was concluded. So, my lord, we were ready for final arguments. At that stage, my lord, the presiding arbitrator, my lord, had become unavailable. The presiding arbitrator, my lord, after returning, my lord, there was a sitting held to, my lord, obtain the consents. That sitting, my lord, the presiding arbitrator has recorded, my lord, the sufficient cause, my lord, which prevented the tribunal, my lord, from concluding the arguments. My lord will find that, my lord, in the minutes of the 54th sitting, which is, my lord, the last entry in my list of dates, my lord, and the minutes, my lord, is at page 78 of my petition. May I, my lord, place that minutes? May I, my lord, place, my lord, page 78? My lord, paragraph 1. Today, the respondent has filed an application pointing out that the mandate for the
1
tribunal
minute. The matter cannot be decided finally today because the respondent intends to file an opposition to your application. So you have to give time. Please come.
Yes, my lord.
Yes.
Yes, my lord, usually, my lord, no question, my lord, scope for affidavit, my lord, opposition to this, my lord, consent. If your lordship sees the minutes, my lord, it was their case before the tribunal itself, my lord,
The
that they
instant
could.
application has been filed seeking extension of time for passing the award. Stop. It appears that the time period within which the arbitral award had to be passed expired on 21st of November 2025. Stop. It has been submitted that the award could not be passed due to the health issue of the
Presiding arbitrator.
Presiding officer of the arbitral tribunal. Stop. Learned advocate representing the respondents. Respondent, one respondent only. Seeks time. Now, first Ligun opposes the prayer of the petitioner. Stop. A prayer has been made to permit the respondent to file an affidavit in the matter. Stop paragraph. It appears now, as it has been submitted by the learned advocate representing the petitioner, that the time period within which the award had to be passed expired in November 2025, and the present application has been affirmed on 19th of June 2026. June. Accordingly, the court intends to allow the respondent to file a short opposition in the matter. Stop. Let the opposition be prepared and circulated within a period of 2 weeks. List the matter in the next circuit. Stop. Reply to the same may be filed prior to the next date of hearing. The point of maintainability of the instant application raised by the respondent is left open.
I'm
Yes,
grateful.
affidavit of service is taken on record.
I'm grateful.
Yes. Four 445.150 kgs of ganja. Hmm. Hmm. Yes. Anticipatory. Now he is in custody. No question of anticipatory. Right. Yes. Case diary. Yes.
176. Location of this person, provide our location from India. This person was very much there on 66 and 76. The day before the procurement and transfer to Calcutta in India. Thereafter, was his previous antecedent was resulted in
Petitioner is Vishwajit Roy.
most important thing is at 54 to find that there is a money trail. He has transferred from 5th of June 2025 to 15th of 2025. Total sum of 1,77,970 for the procurement of this fund.
All right.
From his,
Where do you find that money trail?
the money trail is there at page 254. All electronic plan. He is very much involved in it.
244.
Yes.
And his statement is also. At 12 different occasions, different amount, 1,77,000. Between 5th of June and the date of meeting.
Yes.
I asked them to produce any valid documents for carrying and monitoring of the plant that they paid for the on community intervention. They stated that they had brought a computer substance ganja from Ujjbi from one Mushiluddin Sheikh Ikramul Haq. But subsequently, they are not Sashi. They are a Sashi. Sashi, page number 20. Where arrested from other private persons were arrested on 19/6/2025, 19th of June. The state minister, page number 27 on the first paragraph. On 11/9/2025, he found conduct of accused Harshit Mishra with one Vishwajit Roy. So Harshit Mishra or other accused persons did not voluntarily take the name of this Vishwajit Roy. On 11th of September, Uri's conduct was found from his phone, from the phone of the other accused person, Harshit Mishra. Thereafter, this petitioner was arrested. And from his custody, nothing was revoked. In the paragraph, that on 14/11/2025, he shown arrested, his petitioner was arrested and his found 60,000, 66,000 and 1,50,000 was transacted in his account. But this is a different matter. These are different issues. The transaction was there because
What does this person do? He where from he got so much of money? Electronic transaction? What business?
But very surprisingly, from whom the person has taken the amount, he is not touching.
Yes. Please come. ওপরে নাই এই জিনিসটা এমনি করে লিখে দেবেন
That case also is enlarged on age.
Acha. The petitioner's praise for bail stuff. It has been submitted that he is in custody for how many days by now? 232 days. Stuff. It has been submitted that the petitioner is not the charge sheeted accused. Stuff. His name came up during interrogation of the other accused persons. Stuff. According to the petitioner, the money transactions which have been found in his bank account relates to other business with which the petitioner is involved. Paragraph. The learned AAAG has produced the CD stuff. It appears there from that the page 176 you said that the phone details of the petitioner was tracked and the tower location of the petitioner's mobile phone was found near the place of occurrence. Step. There are electronic money there is electronic money transaction trail, which the petitioner admits. Stop. Next, the quantity of gaja recovered is 445.150 kgs. Stop. Paragraph. Upon hearing the parties, the court is of the opinion that this is not the fit case for grant of bail. Stuff. Next. In view of the above, the application stands dismissed. CD is returned. Asogar. See this. All right. CD not available. Stop on the prayer of the learned advocate representing the state. List. Next Thursday. No, the CD. It will take time. When? Next week? Tuesday. 7th. Why? And he will remain unwell for the entire circuit? Today is just the second day. Next circuit on the prayer. Next week on the prayer next week. Are you ready with instruction? 5? All right.
Lordship, kindly come to page number 22 of the bail application, Lordship. It is submitted on behalf of the learned advocate representing the petitioner that the petitioner is in custody since 19th August 2025 and he has been falsely implicated and mandatory provisions of section 42 of the NDPS Act has not been complied. Nothing was recovered directly from the position of the present petitioner. Today's submission also, Lordship, I'm banking on that only, that nothing has been recovered from him, Lordship.
Let me understand what is the case now.
From the matter, I am facing the CD matter as per mobile tower location matter, they were arrested. This present petitioner. And matter from the co-accused statement, matter his name was matter reflected. Matter and matter the case is that matter through railway matter from Assam to matter Chennai. These narcotic drugs are transported, and he is one of the involved in it. This is the.
And what is the position of the investigation? It's still continuing.
It has been submitted, my Lord. That is why I have before your Lordship.
Charge sheet has been
submitted.
Charge sheet has been
Kindly
submitted.
come to the FIR, Lordship. On the last occasion also, this portion was agitated that paragraph 1, page number 11 of our application, Lordship. Be it noted that on slip suit manner, inquiry could be revealed to put on record that some delinquent persons of Azara, Guwahati, Rangia, after forming a clandestine
75
record
kgs
or
of
hatching
ganja.
up or criminal
Transported from Assam to
Yes,
Chennai.
Lordship, more than one person is involved in this case. Only one person has a charge sheet. Lordship, now the prima facie evidence, Lordship, shows that when the investigation was conducted, Lordship, no consigner or the person who will receive the consignment, neither of them were interrogated, Lordship. And the seizure was conducted from platform number two, where the contraband articles were seized. He was nowhere present. Lordship,
Your tower location says?
No, tower location says, Lordship, that is different thing, Lordship. Kindly look at the CT because tower locations were ultimately found not on that particular day, Lordship. After the seizure, after the arrest, Lordship, the seizure was conducted, his mobile phone was seized, Lordship. From there, tower locations could be located. Lordship, this person is just a loader and ordinary employee. Lordship, his salary is only 16,000. Lordship, there is no money trail regarding this, his bank account, Lordship. Bank account shows that there is no money trail regarding this alleged incident, Lordship.
Must be a very clever person. Amount is going to somebody else's
No,
account.
Lordship, he is just a loader, Lordship. If, Lordship, somebody had to load the particular goods, it should have been the consignor, Lordship. Because nowhere, Lordship, they have been interrogated or not, neither they have been charge sheeted anywhere, Lordship. Only one person's involvement is short. And it is a high capacity parcel vehicle, Lordship. He cannot be involved, Lordship.
Please come. The petitioner prays for bail. He was arrested on 19th
Lordship, charge sheet has
August
already been submitted, Lordship, in this case, Lordship.
19th August 2025. Stop. According to the petitioner, he was only acting as a loader and there is no money transaction that has been found in his bank account. Stop. The quantity of ganja recovered
75 kilos of ganja and,
is
Lordship,
75 kgs.
215 woods were recovered.
And 150 sacks of betel nuts.
And 210 wooden logs and 150 kgs of betel nut. Stop. The paragraph the prayer for bail is opposed by the learned counsel representing the state. Stop. The CD has been produced. Stop. The same is perused. Stop. It appears there from that the
My lord, and previously also it has been rejected.
yes, I've
When
seen
the
that.
charge sheet was not submitted, we have submitted
Yes.
renewal of bail.
আচ্ছা আগের প্যারাগ্রাফে একটা সেন্টেন্স পিটিশনের বক্তব্যতে লিখে দেবেন তো যে the charge sheet has been submitted after conclusion of the investigation. আচ্ছা এবার যেখানে ছিলাম it appears therefrom that during investigation, the petitioner's mobile tower location was found near the place of occurrence of the incident. Stop.
Lordship, because he was an employee, Lordship, his mobile tower had to be found from that place.
The recovery was made from the possession of the petitioner.
Not from his petitioner, from platform number 2, Lordship.
From whom seized,
Caesar
I can
list.
see the Caesar list, it is mentioned from the possession of the petitioner. Sachin?
No, not from Sachin, Lordship. The recovery is from platform number 2, Lordship. There is no physical, there is no conscious possession, Lordship, and as well as physical possession, Lordship. It was found on platform number 2. That is why there is no link regarding his, Lordship, actions in this alleged offense, Lordship. Kindly see the list. He is from platform number 2.
Where from are you seeing?
Caesar list, page
Yes,
number.
Caesar list, it's very legible.
Yes,
Have you
I will
annexed
give a
it?
copy. Yes, Lordship, I have a copy of the Caesar list.
Have you annexed it?
Yes, I have annexed it.
Which page?
Caesar list
From the possession of Sachin.
Caesar list is at page 18, my lord. Page 18.
Page 20, please come.
Page 20. What is seized from page 20 is after the arrest, Lordship, his mobile phone was seized, not the contraband articles, Lordship. Contraband
Place of
articles were
Caesar is
seized
such and such.
on 5/6/25.
Oh, wow.
During the course of investigation, Lordship, his
Achha,
mobile phone was
mobile
seized and he
phone
was
was
arrested.
seized. And where is the Caesar of articles over
Caesar
here?
of articles is at page number 18. Page 18.
Hmm.
On 5/6/25 in between 7 5
Platform
hours
number
to 14 5 hours at platform number 2 of NGP.
After lifting the articles.
Railway
After
station.
lifting the articles, it is you who lifted the articles.
Because I was a loader, Lordship. That is why I was
बोलना
wrongly
मतलब?
framed, Lordship.
Now, position recovery was made from platform number 2.
Lordship, charge sheet has been
After
submitted in
the
this case, Lordship.
Contraband articles were lifted from the high capacity parcel vans. Step. The petitioner was responsible for loading the articles. Step.
Lordship, he cannot open the parcel, Lordship, because it is a high capacity parcel. He's just a loader, Lordship. That is what I'm trying to say, Lordship.
Yes, yes.
He's
I
just a
have
loader,
followed.
but he did not have any clue, Lordship, because the railway
What is
officials
there
are also,
inside?
Lordship.
The petitioner didn't have a clue what is there inside. He simply loaded it.
Yes, because it was brought from Delhi
One place.
Yes, in the middle, Lordship, NGP station, Lordship, it was seen that
It has been
from the
submitted that the
articles, Lordship,
contraband
this contraband
articles
articles was there.
were being transported from Assam to Chennai. ঠিক আছে?
Officials have not been questioned. Just made escape.
Upon perusal of the CD and upon hearing the submission made on behalf of both the parties, as it appears that the contraband articles are of commercial quantity, accordingly, the prayer for bail stands rejected. CD is returned.
Lordship, kindly give this. Lordship, Lordship, I would like to submit supplementary affidavit regarding this case, Lordship. Kindly give me one more date, because Lordship, I have ample proof that the consignor and the consignee was not interrogated, and he was a mere person.
Come after
Lordship.
some more days. Yes, it will be. Next.
Come after some more days.
Actually, I'm paying for next circular. Item 7, the conducting counsel. He has gone on eye surgery recently in the vacation. So unfortunately, he's not able to.
Vacation, where is the vacation?
No, in the last vacation, that's what I'm saying. He has recently gone on eye surgery. The conducting counsel.
Yes.
I'm playing for next circular.
Ready? Are you ready with the matter?
I'm ready.
Then somebody else should appear and take steps.
Lordship, I have just received the instruction that he's unwell, and I mean he has gone on eye surgery. That's the problem. He's unable to travel outside because he might
him join
contact
online?
the dusts and all.
Why doesn't he join online?
That I have no instructions, Lordship. Your Lordship, kindly please
It
next
has been
circular.
submitted that the learned advocate representing the petitioner has undergone an eye surgery. Stop. Accommodation has been sought for on his behalf. Stop. Next. In view of such submission, list the matter in the next circuit.
Grateful, Lordship. নামটা দেব? আচ্ছা, ঠিক আছে।
Item number 8. Item number 8, my lord, I am for the petitioner, my lord. My lord, I'm praying for day after tomorrow, my lord.
Day after tomorrow on the prayer. Who's for the state? Ready with the CD? All right.
Yes, my lord.
Next.
Grateful.
অন্য কোনো নাম কেন দেবো? সেন্স আছে।
Item number 9. Item number 9, I'm paying for not this week, madam.
Not this week.
This.
Item number 10.
Item number 10.
Yes.
Lordship praying for not this week, next week.
Why? Yes.
Not this week. please.
Why? You have to mention some reason for seeking adjournment. Why are you seeking adjournment? Please face your case.
Gone out. কি কর কি কর
Section.
করে দে কি কম
59.8 kg gaja.
Yes, Lord.
Yes.
Under section Lordship 20, subsection B, charge sheet has been submitted.
Right.
Lordship, kindly see. Case number. Lordship, kindly see page number 21, annexer P4.
Yes.
Memo of arrest.
Yes.
Resident of
Possessing and transporting illegal ganja.
He is resident of Meghalaya, but
Yes.
ground of arrest he communicated language at Bengali. Okay, na?
Yes, what is the submission?
Ceased from the exclusive condition of the accused person. There is no such proof or evidence at this relevant point of time that he understands only the medium that is in Bengali.
Stop.
Only he can grounds of arrest should be given on the language.
59.8 kg gaja.
Lordship,
It's a gaja-like substance.
Lordship,
Yes.
Lordship,
Lordship,
Has been.
one day accommodation may kindly be given because my junior could not explain what is the grounds of arrest. Grounds of arrest, if there is no grounds of arrest, that is a clear violation of Article 22(1) of the Indian Constitution. And there are catena of judgments, including the latest judgment of the Honorable Apex Court in Mihir Rajesh Sheikh's judgment that grounds of arrest is mandatory and that should be given before 2 hours of production before the magistrate. And if such no such grounds of arrest have been given, then there is a difference between memo of arrest and grounds of arrest. Memo of arrest is the reason of arrest, and grounds of arrest shall be self-explicit and shall be in the language which the accused understand. And even in a form of a template, if it is given, that should not be should be the legal grounds of arrest. And in that case, the release of the accused is immediately is mandated. So one day adjournment may kindly be given.
Right.
All the judgment will be produced.
Show it now. What is there to show that you do not understand Bengali language? You are,
He's from
So what?
Meghalaya. And what's his name?
You are also from West Bengal. Do you not understand English? It is this.
No, actually, Honorable
The contraband articles were found from your possession.
in the case of Mihir Rajesh Shah versus State of Maharashtra 2025,
Yes.
the Supreme Court has clearly stated the language the accused should understand. That should be, in such a language, the grounds of arrest should be written.
I will not take soft copies.
One day accommodation, Lordship, for the sake of justice.
Tomorrow.
Much obliged.
Not today.
Your Lordship, I'm praying for a week's time. I've received the brief today itself, Your Lordship. Kindly keeps it on Tuesday, Your
Where is the
Lordship.
advocate on record?
Advocate on record is on his legs in courtroom number 5, Your Lordship.
Then,
I'm his junior.
so
That is why I'm asking. We have received the brief today, Your Lordship.
how can you receive the brief today if you are the advocate on record?
I am not the advocate on record, Your Lordship. Advocate on record, I don't know where is he, but I have received, I've been given the
You
counsel
said
brief,
just
Your
now
Lordship.
the advocate on record is in the other court.
It's in courtroom number 4, but I have received, he has handed over the copy to me today itself, Your Lordship.
So,
I'm not prepared, Your Lordship. Kindly keeps it on Tuesday. I'll do the matter, Your Lordship.
only not today.
Grateful, Your Lordship.
Item number 12. 12.
Not today.
Item number 13.
Item number 13 is bring for next week, my lord. As you can the conducting activity suffering from fever, my lord.
On the prayer adjourned for this week. 13, the state is there. Ready? Bring it.
Grateful.
14 item number.
I'm for the petition of my lord. I don't know 14.
Yes.
Give your ladyship be pleased to fix it for Thursday one.
Thursday.
Thursday. Second.
All right, Thursday. On the prayer, Lisbon Kintu. Thursday.
Grateful.
I don't know 15.
15, my lord, I'm for the petitioner, my lord. The certified copies of the trial court records is required, my lord.
Why?
For
For
purpose
bail?
of application. Yes, my lord.
Why?
My lord,
How did you file the
my lord, to
application?
find out some, my lord, some procedural irregularities are there, my lord.
Then not press it,
Videography, my
file
lord.
it when
No,
you
my lord.
get the
My lord,
copy.
kindly place the matter before next week, my lord. I will do the, in the meantime, I will collect the certified copies and do the matter, my lord, positively, my lord. Next week, my lord. Kindly, my lord.
State.
CD is not available. I will see.
Next week?
Next week.
Adjourn on the
Yes,
prayer
my
of
lord,
the
yes.
petitioner.
Grateful, my lord.
Item number 16.
Petition ta kothay?
18 July 2025. The case of the prosecution is that he had entered India illegally some 11 months prior to 18/7/2025.
Yes.
I am only seeking exemption under the notification passed by the government of India, whereby Hindus, minority communities from Bangladesh, including Hindus who had entered India on or before 31st December 2024, are saved from the provisions of the Foreigners Act, my lords. My lords, let me at page number 38, my lords.
Yes.
Part E, my lords. A person belonging to a minority community in Afghanistan, Bangladesh, and Pakistan, namely Hindu, Sikh, Buddhist, Jain, Parsi, and Christian, who were compelled to seek shelter in India due to religious persecution or fear of religious persecution, and entered into India on or before the 31st December 2024 without valid documents, including passport or other travel documents, or with valid documents, include passport or other travel documents, and the validity of such documents have expired. So, my lord, they are exempted from the same. From the prosecution under Foreigners Act, my lords. So, my lords, the FIR is, my lords, we come to page number 15. That's the written complaint. Third paragraph. The suspected person was intercepted upon reaching at given location 900-meter approx from INB near BB Panitanki Market, Darjeeling, and was caught around business time. On the spot, spot interrogation, the individual revealed that his name was Mohanto Burman. Burman, resident of Village Street, my lords, here the address is given as Bangladesh. And on his interrogation, my lords, in the it says that he admitted to having entered in India approx 11 months ago through an unauthorized route across Indo-Bangladesh border at Bhavesh Singha building near Kali, and has been staying in multiple places for employment purposes. So, my lords, the case of the prosecution itself is that he had entered prior to 31st December 2024, my lords. And that's what I'm seeking exemption under this provisions of this act.
But there was no fear of religious persecution, isn't it? Then
No,
why will your bail be allowed?
No, my lords, he had fear of religious persecution. I've stated in my petition. My lords very well knows the condition that is prevailing.
And that is more so the reason for not entering. What is the stand of the state?
My lords, we kindly.
CD is not available. Kindly one day.
Ye judgments ko de de.
My lords, we kindly see the
View of the coordinator.
My lords,
I did
my lords, my lords, we kindly see this order passed by the coordinate bench.
Yes.
Only issue is that it is not up to the up to that is that Mohanto Burman is the resident of Bangladesh. There is another issue. What is there is that Indian documents like Aadhaar card and PAN card has been seized from the FIR. We will get that.
Indian documents like Aadhaar and PAN. Yes.
That is the issue we need to look in.
What is the date of the Aadhaar and the PAN has to be checked.
We are not holding the screen now. And be placed day after tomorrow.
You are relying upon an order of December 2025, right?
Yes, my lords.
And when the matter was moved just a few months back, you not pressed your application in March 2026. This order was very much there at that point of time. You did not rely.
Yes,
and now you want to rely on it. Why?
What happened?
No reason.
My lords, I'll have to seek instructions on this.
There is nothing to seek instruction.
My lords, he is in custody for almost a year now, my lords. The minimum
Nothing can be
punishment.
done. Now pushback will be there, and then after
My lords, we
something
kindly allow
is
him to at least try for religious.
certainly not. Please come. The petitioner claims to be a Bangladesh citizen. Stop. He seeks exemption in terms of the order of the Ministry of Home Affairs dated 1st September 2025. Stop. Reliance has been placed on the order passed by a coordinate bench of this court on 22nd of December 2025 in CRM. In the matter of how are they two related?
My lord, the other person, my lords.
Yes.
The other person had allegedly helped him in procuring the Indian documents. He was released on bail.
Very good. Reliance have been placed. ঠিক আছে?
Another co-accused
Um,
person, right?
Learned advocate representing the state opposes the prayer for bail. Stop. It has been submitted that despite the petitioner being a Bangladeshi national, comma, he was able to obtain the Aadhaar card and PAN card in India. Stop. Paragraph. The learned APP seeks time to produce the case diary. Stop. On such prayer, released on 7th July.
Grateful, my lords.
Lordship, in item number 21, I'm paying for next circuit.
Why?
The conducting counsel is he's not well, so he has instructed.
He is not well or he has left practice.
No, he is not well. So
What is he suffering from?
he's not feeling well actually.
Feeling well? Tomorrow.
So kindly,
tomorrow
maybe
he'll
next
feel well.
circuit.
Tomorrow he'll feel well. All right.
Oh, yes.
Not today. Next.
I don't know which two.
Lordship will prefer next week, Lordship.
Next week.
Lordship.
This matter was called on yesterday, isn't it?
I was no, Lordship. No,
কালকে
Lordship.
মামলাটা ছিল না? The matter was called on yesterday. It was adjourned. Today also, why
Lordship,
adjournment will be granted?
Lordship, conducting advocate Mr. Sudip Guha, he is suffering from fever.
Tell him to join online.
Lordship, kindly make it not this week, Lordship.
Why not this week?
Lordship, he is appear physically.
He'll appear physically? All right. On the prayer, not this week.
I don't know 23.
23, my lord, I am for the petitioner, my lord. This is also Foreigners Act, my lord. They all are the Hindu, came to India before 2024 as per the notification and applied for the citizenship, CAA. And there I have annexed all the documents, lordship. And during pending of my application, police arrested and
17th of June 26.
my lord.
17th of June, Sanjeev Chaudhary. Who are you? Ranju Mojumdar. One of your co-accused has not pressed it.
Yes, my lord.
Then, are you interested?
No. He is granted bail from the court below.
All right.
He is Indian. Well, similar situation, lordships. Coordinate bench granted the application, lordship. Similar situation, similar case type, lordship.
The APP is not ready with the CD or anything. Come ready next day.
Similar situation, lordship. Coordinate
Yes.
bench.
This is not in connection with this matter, is it?
Not
It's
this
similar.
matter, lordship. Similar
right.
coordinate bench granted,
All right.
lordship. Why the
The
CAA
petitioner
application?
is a Bangladeshi national. Stop. ওই আগেকার যে আইনটা বললেন না, গভর্নমেন্ট অফ ইন্ডিয়ার অর্ডার। Yes, right. Exemption বলতে হবে। হ্যাঁ, এই যে 1st September 2025, ঠিক তো? Reliance has been placed on এই যে এইখানে দুটো আলাদা অর্ডার দিয়েছে। 27 এপ্রিল 26 CRM এইটা in the matter of এইটা, আর একটা 30 মার্চ CRM এইটা 14 এইটা, ঠিক আছে? On the prayer of the learned APP seeking time to revert with necessary instruction, released on 8th of April. July.
Copy to copy. দিয়ে দিচ্ছি judgment গুলো থাকবে
Let it remain in. Yes.
I am for the petition. Rashid, the allegation is under section 306 of the Indian Penal Code. I am in custody for 93 days, Rashid. In this case, Rashid, the allegation is that the de facto complainant, his daughter was committed suicide by consuming poison. And FIR was lodged against unknown persons. And thereafter charge sheet was submitted against 10 persons. Out of these 10 persons, the petitioner name transfer is item number
See,
9.
Shoma Sarkar and you stand in the same footing, I can see. Right?
Rashid, all
And
are
your name has come up during the, in the 164 statement, which has been videographed. The co-accused has been rejected bail. Why will it be allowed in your case?
Rashid, in the month of April, with Shoma Sarkar, the petitioner was also there.
Yes. So
Dulal
Shoma's
Sarkar was-
bail has been rejected.
Dulal
Why will
Sarkar's
it?
bail also was rejected.
So your bail will also be rejected?
Kindly see the case diary where the involvement of the petitioner, Lordship. Kindly see.
What is the reason to see?
Because Lordship, 306, your Lordship knows, unless there is the abatement, 306 cannot be proved, Lordship. And
Please come.
Lordship, kindly see the statement once. Kindly see the involvement of the petitioner, Lordship. I'm in custody for 93 days. Kindly see, Lordship.
And the petitioner claims to be in custody for 93 days.
93 days.
90?
90.
No boy. 90 days. Stop. It has been submitted that he has been falsely implicated in the case under section 306 of the IPC. It appears from records that the prayer for bail of the co-accused stood rejected by the court. Stop. You have the CD? Acha.
Then Lordship, kindly adjourn.
Prayer has been made to peruse the CD prior to passing any order in the matter. Step. Very well. As the CD is not available today, hearing of the application stands adjourned. Stop. Released on 7th of July.
Item number 25. 25, my lord, I am appearing on behalf of the petitioner. My lord, this is appearing for the first time. It's application for cancellation of bail.
And why do you seek cancellation? Who are
My
you?
lord, I am the complainant wife, my lord. The appropriate sections is not incorporated by the police department, my lord. That is why I am seeking for cancellation of the bail.
Did you serve?
No, my lord. This is the first time appearing.
Acha. The petitioner claims to be the wife of the accused, Vishal. Vishal Das. Stop. Let a copy of the application be served upon the opposite parties. Stop. Release the matter. When?
Next circuit, my lord. Next circuit, my lord.
In the next circuit.
Grateful.
I'm for the petition. Not
Lordship, I appear for the.
This is affidavit of service. So assailing the order dated 15th of October 2025, whereby the private opposite party has been granted anticipatory bail. I have assailed this before your petition.
Yes,
This is a cancellation from order of anticipatory bail granted. Now, what I have seen, Lordship, though being the senior judge, Lordship can take the matters, but cancellation from anticipatory bails, Lordship, I have seen that it is on before the court number 5. But Lordship, this is the
let me check up once. দেখি তো লিস্টটা পুরো লিস্টটা দিন না
On the last occasion,
এটা তো শুধু আমার
when the
list
matter was
আছে।
taken up, it was before the bail court.
এটাতে শুধু আমার লিস্টটা আছে এন্টায়ার লিস্টটা দেখি না
Cancellation দিচ্ছে তো এটা যেহেতু
If this bench doesn't have determination, how can the bench take up the matter?
No, on the last occasion,
Lordship can always take
No,
any
no,
matter.
that is no. There is a specific bench.
No,
Criminal matters, excluding matters to be heard by a single bench.
Automatically, because on the last occasion, when the
How can the anticipatory bail be taken up by this
No,
bench? Because these matters are
it has come up
from the
automatically
department.
from the
All right.
department, because on the last
the
occasion,
matter-
the bail court has taken this
All right,
cancellation
all
of
right,
bail.
all right. Let this matter be placed before the bench having determination.
Grateful, Lordship.
Let the affidavit of service be read.
আচ্ছা তার আগে লিখে দিন the matter relates to cancellation of anticipatory bail.
To affidavit.
Lordship, we have appeared, Lordship.
Yes, yes, your appearance will be recorded.
Yes, yes.
Service be written with the records.
Affidavit of service be written with the record. Deeply.
Deep job, Lordship.
Deeply.
Item number 27, for the petition. This is a modification of the order passed by the Honorable Court. Now, my lord, can you see the order was passed in the month of 25th of February 2020. The relevant portion is, my lord, at the page number 8, the last paragraph. I have been released on bail with a direction to meet the IO once in a week. Since last 6 years, I am complying that order.
Did you serve?
My lord. Since last 6 years, I have annexed the.
1 minute. Let me see. Has copy been served?
Yes, copy been served. Since
What is the status? Whether the petitioner is acting in accordance with the conditions or
My lord, I have annexed already. Can you see the page number 10 and onwards? Since 10 and onwards, since last 6 years.
Show me the condition once.
My lord, page number 8.
Page number 8.
Paragraph number last but one. That is commencing accordingly. Accordingly, we direct the petitioner, namely Kaji Roshan alias MD, be released on bail of 5,000 with 2 sureties of like amount, each of whom must be local, so and so, on further condition that the petitioner shall meet the officer in the Kotwali police station once in a week, starting from 1st March 2020. He was released on bail by, I am saying, he was released on bail in the year after lapse of a year. He was released on bail on 26th February 2021. Kindly see the page number 10, my lord.
The order was passed in February 2020.
20. I was released after lapse of 1 year.
Why?
There is another case is pending against me.
All right.
And on 26th to 2021, page number 10.
First day.
First date. Since today, kindly see, my lord.
All right. Let a report become. Please come. The petitioner prays for relaxation of the
13th
condition of bail imposed on 25th of February 2020. Stop. It has been submitted that the petitioner is meeting the officer in charge of the police station once in a week for the last 6 years, and he has not missed the said condition even once. Stop. The learned APP is directed to produce a status report on the adjourned date. Next Wednesday, I keep it, 8th. Yes.
I cannot meet it.
Yes, I am appearing for the petition. Lordship, this is a prayer for modification of the bail order on page 7 and 8. 6, 7 and 8. Page 7, last para, Lordship. In this case, there are total 11 accused persons. All the accused persons are enlarged on bail, and this petitioner also enlarged on bail. The last para is, he shall appear before the trial court on every date of hearing until further orders, and shall not intimidate witness, not tamper with evidence. Now the last para, the petitioner shall not enter into the jurisdiction of police station where the de facto complainant permanently resides, excepting the date as fixed by the learned trial court. The petitioner's residential place and the de facto complainant's residential place is same. Now, Lordship, other accused person, the petitioner's 5-year-old son is suffering from page 10, suffering from mucosal thickening noted in right maxillary sinus, that is severe sinusitis, and the petitioner has till to date has not entered there. And on other accused, the person who was also granted same condition was condition has already been modified, the same condition by the coordinate bench.
No, page 10 is the CT scan of the brain of your son, you say.
Yes.
Where
Master Mannat Ali.
Right, where is the difficulty?
He is suffering from severe headache. He cannot enter into his house. So he cannot, he is not in a position to support his son for the medical treatment.
What type of support?
He has to take him to the, because where he resides, the nursing homes and every doctors are in the same jurisdiction under the suppose Bhaktinagar PS, Bhaktinagar PS, NGPPS, New Jalpaiguri. And other accused person, that is Muhammad Salahuddin, same condition was imposed and relaxed by the coordinate bench.
But you obtained bail only in February 2025.
And this is 2026.
Yes, hardly 6 months are over, and you want relaxation.
Other
Let me see
accused
what is the other order that you are relying upon?
This was the this is the order, and this is the correction of the order.
Let me see.
Yes. Here also they are also medical ground of father or something, maybe son of child.
Is it connection with the same case?
Same case, same case.
And everybody's son is suffering. How can that be? Your son is also suffering and the co-accused son is also suffering?
That may be a coincidence.
No.
Lordship.
This raises doubt in the mind of the court.
No question of doubt.
What? No.
They underwent a long incarceration.
So what? That is
and the
something
family,
different.
And the family always suffered. Even anyone of the family members go for incarceration, and that time ailment occurred. And
Yes. When at the time of
Lordship
committing that crime.
Lordship is a senior judge. This is a mere modification, Lordship. Simple modification.
Mr. Chatterjee is appearing for
So what?
Wow, Mr. Chatterjee is appearing. So what is
It hardly matters who is appearing and who is hearing the matter. It's of absolutely no consequences.
No consequence. Actually, Lordship,
we are dealing with people who are not present in court.
Present in court, and Lordship, actually, I have shown the CT scan of the brain. And,
yes.
And
the very fact that you said that your co-accused son is also suffering from the same problem.
Not
and
same
you are
problem. Not same
suffering
problem.
from
It's other ailment. Other ailment.
All this
Ailments.
Ailments
are there. And 2024's case till today, no commitment has been done. Only CS has been filed.
Where is the last page of the order? Third of July 25, where is the last page of the order? It is missing.
Sorry, Your Honor. I beg pardon.
July. 3rd of July 25, relaxation. You got bail on 17th of December 2025. That means after the condition was relaxed for Mohammed Salahuddin, you obtained
Obviously,
bail.
Lordship took it correctly. But that was bail at different times. Bail at different times. Lordship kindly allow the accused to enter into his house.
2025, specifically the condition that the petitioner shall enter the jurisdiction. What is your submission?
My lord, charge sheet submitted,
Hmm.
my lord, but for that discrepancy, my lord, a status report may be called for from the High.
What type of status report?
My lord, whether what he is stating.
He is saying that his son is suffering from a medical illness. What status report will the police give in this case?
Whether this is true or not.
Police will inquire as to
Police-
whether his son is suffering from any illness.
And because previously also on the same ground, the co-accused has been relapsed.
Right. Yes, this I can understand. But will the police be able to find out?
We may go to the present petitioner house and ask for that. These are documents.
And go and threaten. This is what the police is doing. Is the police doing anything else? No.
I am holding the case diary.
Yes.
And from here I can see that and
No. The cases of NGPPS
Yes.
and the residents of the
Petitioner, where is it? Where does he reside?
No, within NGP. Within NGP.
Bhaktinagar. So initially there were Bhaktinagar was under NGPPS was under Bhaktinagar case initially, but now these are
Bifurcated.
these are two separate police stations.
Hmm.
So there is an order not to enter the jurisdiction where the victim resides.
Both reside at the same place within the same
Both
jurisdiction.
same-
The issue is that now it is NGPPS.
Yes.
Cases of NGPPS. He resides now on the cost title you will get that he does not reside in NGP. He resides in Bhaktinagar.
Yes, I have written that.
Assuming he resides in Bhaktinagar, the de facto complainant.
He asking that I should enter into my house.
My house.
His prayer is that he should be allowed to enter his house. So if the incident is of NGPPS and the victim is from NGPPS,
The victim from Bhaktinagar.
Same. Both of the same place. They are not from different police stations that he can enter.
That's why I am suffering.
Yes, that I can understand. Please come. The petitioner prays for relaxation of the condition of bail imposed on 17th December 2025 in CRM within bracket M 384 of 2025. Step by the said order, the petitioner has been restrained from entering into the jurisdiction of the police station where the de facto complainant permanently resides, accepting the dates as fixed by the learned trial court. Stop. Learned advocate for the petitioner submits that his son, তার আগে লিখুন, be it recorded that the petitioner and the de facto complainant resides within the jurisdiction of the same police station, that is Bhaktinagar.
No, Lordship.
NJP? Both NJP?
Ajmera Begum is NGP.
আচ্ছা, দুটোই NJP.
No, Lordship. Ajmera Begum, the de facto complaint is from NGP.
And he is from Bhaktinagar. Check up petitioner.
Lordship, this side Bhaktinagar, this of the other side of
No,
the road
that
is
is
NGP.
different. All along your submission was that both reside within the same PS. Please check, because wrong submission of yours will be recorded.
What is the problem then?
Where is the problem? If they reside in two different
Police is
stations,
not
there is no
allowing,
problem at
according
all.
to my junior, police is not allowing to enter because the house of the petitioner is the junction point of the Bhaktinagar and NGPPS.
What does this junction point under two different police stations?
Yes.
Absolutely.
There are several junction points between.
Yes.
Because previously NGP and Bhaktinagar was the same police station, and subsequent after bifurcation, bifurcation, NGP and Bhaktinagar get separated.
না, এটা তো ভুল হয়ে যাচ্ছে, লিখুন ওখানে be it recorded লিখতে হবে, be it recorded that the petitioner resides
And for one submission for purpose of treatment also, he has to come to NGP police station because NGP railway station is also there.
আচ্ছা, it has been submitted, be it recorded. It has been submitted by the learned advocate for the petitioner that he resides at the his house is at the junction of the Bhaktinagar and NGP police station. The residence of the de facto complainant is within NGP police station. Stop. The paragraph বললাম ওর ছেলের অসুখ হয়েছে, is suffering from health issues and he is undergoing medical treatment within the jurisdiction of NGP police station.
Yes.
Stop. The police is restraining the petitioner from entering into the NGP police station. Stop. Prayer has been made to relax the restriction so that the petitioner can enter within the NGP police station for supporting his child during his medical treatment. Step. Learned advocate for the petitioner relies on the order passed by the court in respect of another co-accused on 3rd July 2025 in CRM within bracket M/28/2025, IA number CRAN 1 2025, Mohammed Salauddin and another. Wherein the restriction not to enter the jurisdiction of NJP police station stood waived. Stop paragraph. Acha. Learned APP submits that the petitioner and the de facto complainant do not reside within the same police station, and as such, the restriction imposed upon the petitioner will have no consequences on the medical treatment of the petitioner's son. Stop paragraph. Upon hearing the submission made on behalf of both the parties and on perusal of the documents annexed to the application, it appears that the petitioner has relied upon the CT scan of the CT scan report of the brain of his son, Master Mannat Ali,
5 years old.
aged about 5 years. Stop paragraph. As the petitioner pleads medical reason for seeking waiving of the restriction, accordingly, the restriction imposed upon the petitioner stands modified to the extent that the petitioner shall be permitted to enter within the jurisdiction of the NGP police station where the de facto complainant permanently resides only on the days the petitioner is required to assist his son for his medical treatment. Stop. The petitioner, on regular basis, will not be permitted to enter into the jurisdiction of the residence of the de facto complainant. Stop. The rest of the conditions remain the same. The application stands disposed of.
Much obliged.
For the
petitioner, my lord, it's the case of section 8 of POCSO Act. I was enlarged on bail by the Honorable Coordinate Bench. That is on
देखिए. Where is Mr. Ajay Singhania? Please give a phone call to him. Tell him to come. Pass it over for the next matter.
Number 31.
Walter Rahul.
32. 33.
Must these my application, my lords. Lords, by the order dated, my lords, 15th of December 2025, my lords, had directed, my lords, the police authorities, my lords, to, my lords, take strict steps in terms of the order dated 27, that is the order of injunction, my lords, directing police help. Now, my lords, till date, my lords, no action has been taken, my lords.
Well,
And my lords,
the trial court order is there.
yes, my lords.
Injunction order is still
My lords.
valid. Why don't you approach the trial court for necessary relief?
My lords,
What is the police
what has
supposed to
happened, my lords,
do?
is we had filed an application under Order 26, Rule 9 for Commissioner, my lords,
Right.
for Pleader Commissioner. Even he's been obstructed, my lords. My lords, so kindly see page 18, my lords. It has been, my lords, reflected, my lords. Page 18,
Yes.
first line, my lords.
Hmm.
The Pleader Commissioner has submitted his report on such
He
and
was
such date, my lords,
obstructed by the
stating that he was
defendants,
obstructed by the
But
defendant.
this you could have brought to the notice of the learned trial court and obtain order.
My lords, again, it has been fixed for Commissioner's report, my lords, in the trial court. This was brought.
That you can approach under Article 227 and obtain necessary orders. Here, the direction was passed to take steps in terms of the civil court order in titles of numbers such and such.
As the injunction, my
Brought
lord,
to the
they have been
notice
trying
that
to
20
construct, my lord,
27 November
over the school
25
property.
passed an order directing the officer in Mathigara police station to take steps as mentioned. The concern has already acted. Hmm. Show me the order of 27th of November 2025.
That's page 17.
Right. What was the direction upon the police?
Lords, to see, my lords, that the
To visit the
defendants
suit
do not
property
encroach upon the property
and
and
vigil and shall look into the matter if there is any violation of the court's order. Provide assistance to the plaintiff and then when you say the commission work has not been permitted to be held?
no, my lords.
Alright, you serve notice.
My lords. And my lords, regarding notice, my lords, the incumbent needs to be, my lords, made a party, my lords. This is, my lords, that is, Mr. C. Sudhakar was the former commissioner, my lords. Now, my lords, present is Said Wakar Raza, my lords.
Commissioner, you change, but commissioner is not the person responsible. It is
inspector in
the
charge,
IC
ma'am. Yes,
Mathigara
ma'am.
police station, isn't it?
He has also managed, the incumbent is Manojit Sarkar, my lords, not Arindam Bhattacharya. Currently.
All right. Leave is granted to the advocate and record of the petitioner to implead the present incumbents as contemners. Stop. Let copy of the contempt application be served. Released on 8th July. I'm keeping it.
My lords.
Next week.
My lords, agreed.
You make the necessary correction here and now. Please do not strike off whoever is impleaded. You simply add the other two who are the present incumbents. $34.
And for the applicant,
Yes.
non-compliance of your lordship order dated 22nd of December 2023, page 15.
Yes. Who is to comply?
My lord, the authority is directed to proceed and.
Which authority?
My lord, under the act, it says the SDO and the district magistrate has to comply because it is the panchayat.
Panchayat area, my lord.
As the authorities are the authority.
Respondent number 3 and district magistrate is respondent number 1.
HDA has issued notice to the person
Yes.
responsible for making construction.
Yes.
Right.
So they have come to a finding that unauthorized construction detected.
Hmm.
Thereafter, demolition part the SDO will take care of.
Hmm. Yes, but has the documents been forwarded by SDA to the SDO? That you do not know. All documents are to be forwarded. How will the SDO know that there is unauthorized construction till he is intimated?
My lord, copy of the order has been communicated. Yes.
From the SJDA? Check up?
My lord, let me serve and come back, my lord.
Yes, that is all right.
My lord, next page, immediately order was communicated, my lord. Thereafter, contempt notice was served, my lord.
Chairman SJDA, officer in charge, SDO. See, I can see you've served the copy of the order, but did you serve the copy of the
Contempt application also.
No, not contempt. Have you served the contempt?
Yes.
Why?
No, serve the contempt notice.
Or copy of the order of the court did you serve?
Yes. Page
17.
Yes, my lord. Annexure B. Immediately it was served. Just the next.
Immediately it was served. Was the demolition order and everything served? You have to show that the contemner was aware of the order and acted in violation of the same.
My lord, contempt, the order was communicated to the respondent authorities, my lord. From their end, nothing has been done till date.
Achha, notice issue upon the contemner 8. Chairman SJDA and contemner number 2. SDO Siliguri.
My lord, as the district magistrate.
Why? Why you want to impede the DM? What role the DM has got to do over here?
My lord, the DM as well as the SDO has the authority to demolish.
No, the SDO can look into it. Serve notice. Come back next Wednesday.
My lord, upon the respondent number.
1 and 2 na. 2 and 8 pull to SDO and chairman.
2 and 8 only.
SDO and chairman. Please serve.
I shall serve the GP as well as I shall serve.
Not the GP. This is contempt. You have to serve it directly.
Directly by speed post as well.
Yes.
The course of this, I shall serve.
Item 30. Order has been complied. Yes, this is the reason I do not see you. But then since it is pending, I have to record an order. Order complied. Disposed. Item 30.